Hello, on behalf of the organizers, I would like to welcome you to Forum on Investor-State Mediation, conducted by the British Institute of International and Comparative Law. My name is Yari Krivoy, and I'm director of the Investment Treaty Forum here at the British Institute of International and Comparative Law, which is an independent institution working on various issues of international and comparative law. We organize events and conduct research on diverse range of subjects. And when it comes to the Investment Treaty Forum, more specifically, our events are usually about international investment law, but sometimes we go into other areas. And very often we talk about dispute resolution. Last month, we organized an event on emissions trading, on international law aspects of emissions trading. And next month we will be launching a study on annulment in investor-state dispute settlement. However, most of our events are about investor-state arbitration. And it's a great sign of new thinking in the world of international investment law that we're organizing an event on mediation, because in the past mediation was not really in the center of attention of practitioners of international investment law. However, following the signing of the Singapore Convention, the interest in mediation has been growing. Earlier this year, some of those who attend this event also attended the working group 3, which is organized by UNCITRAL, where we also discussed issues related to mediation. I know that states are increasingly interested in mediation as a way to reduce costs, as a way to find dispute resolution mechanisms which are less confrontational, which also allow them to save not only their face, but also to save money, because as we all know, investor-state arbitration is very expensive. So these are some of the reasons why we thought that it would be a good idea to organize a major event, a big event on investor-state mediation here at the British Institute of International and Comparative Law. And this event symbolizes also a takeover by BICL from Harvard University as an academic host for the ISDS mediation working group, which we will be mentioning later during the course of our event today. So this event will last for 2 half days. So today and tomorrow. Here in Europe, these are afternoon events. In North America, this will be early morning events, and in Asia, this will be evening events. And then you received earlier today a message with a link to the list of participants. As you can see, the list is well over 100 people representing different governments, practitioners, academics with interest in mediation. Also, that email which you received earlier today included a link to biographies of the speakers. You can also find that link on the website, on the page of the event on the BICL website. There you can also find the program. If you want to tweet or write on LinkedIn or on other social networks about this event, I would encourage you to use ITF Law hashtag, which is also mentioned on the event page. There will be opportunities for questions and for short interventions from attendees, not only from the speakers, but also from other people registered for this event. And this is why we would like you to encourage to use your full name and affiliation in brackets in your Zoom profile, so that it's easier for moderators to understand who is asking this question. And what we will do when a particular question is asked and the chair wants to pick this question, we will promote this person to a speaker, so that this person can use his or her own voice and video to ask a question. I would like to thank our technical team, Liam and Bradley, who were in charge of the logistical aspects of this event. But I would like particularly to thank Wolf von Kumberg, who actually came up with the idea of conducting this event and who did the vast majority of of work related to this event, and also Professor Meg Kenyer, with whom we had multiple conference calls, email exchanges to make this event actually happen. With this, let me invite Dr. Arvid Bell from Negotiation Task Force of Davis Center for Russian and Eurasian Studies of Harvard University to give his introductory remarks. Arvid, the floor is yours.
Thank you very much, Jarek. Thank you for this invitation, and it's a pleasure to virtually meet you all. I wish we could all meet in London, but alas, these days will return at some point. So I just want to make a few remarks about the colloquium a year ago that sparked this conversation that we are able to build on today. And then I'm looking forward for a day or two of interesting discussions. So I'm the director of the Negotiation Task Force at the Davis Center for Russian and Eurasian Studies at Harvard. I'm the lecturer on government, so I teach international politics and research security, economic trends across Eurasia. And what the Negotiation Task Force does is we are looking at complicated international problems from a negotiation perspective. And so with that approach, we hosted almost exactly a year ago the 2019 Investor-State Dispute Settlement Mediation Colloquium. And the idea was, let's bring together ISDS stakeholders from ADR organizations, from regional state offices, from critical industries, from the NGO community, and let's discuss the role that mediation could play in resolving investor-state disputes. So we had a day of very insightful discussions, and it's nice to see a couple of participants here in the chat. I see Frauke and Ken and Alejandro, James, probably a few more. So nice to see you all again. And so maybe a few takeaways that we had back then that we are able to build on now. So of course, from a negotiation perspective, right? So you do not want to approach the ISDS question primarily from a power-based angle or a rights-based angle, not through a legal framework, but from an interest-based perspective. So you ask, what do the stakeholders actually want in a dispute, and why would mediation be appealing to them? And what mediators do is they try to appeal to all sides' interests, right, in finding a mutually beneficial solution. And so we found that one, there seems to be often a lack of understanding of the real underlying interests between, for example, investors, states, but also third-party actors. So more work is needed in terms of active listening in order to understand what the other side is really grappling with. Second, it's not actually, in many cases, very helpful to frame issues purely as a dyad of investor-state, but rather you should think of a lot of these disputes as networks of stakeholders who are all somehow tied into a conflict, right? And you have third parties who also play an important role. And a third takeaway was that these third-party actors, such as NGOs, for example, they can often serve as critical linkages in an interest, in conflict between others, and help those unlock value or maybe uncover creative solutions. So that's a few takeaways, and maybe we can build on a couple of them. And so we were very excited to see, after we had this beautiful day here on the Harvard campus, that a couple of participants sort of took action in their own hands. And so a working group emerged from our colloquium a year ago. And I want to thank Wolf von Kumberg for his exceptional leadership in getting that off the ground. And this working group has since then also produced a report that I understand we are going to hear from also. So yeah, and now this effort has found a new home with BICL in London. And so today and tomorrow we can all build on the discussion from back then, learn from each other. So yeah, special thanks for me also to, as I said, to Wolf von Kumberg, first and foremost. Wolf, thanks for all your work and for your leadership in pulling this off. A special thanks to Meg Kenyer, who was a senior mediation fellow with us a year ago. So he was working with us here on campus, and he has been very inspirational in guiding these discussions. Thanks, Jarek Krivoy, for giving this effort a new home. So thank you for that. And also I'd like to personally thank Catherine Kessidzian for valuable counsel ever since then. So that's it from me. I'm going to leave our negotiation task force's email address in the chat. So if any one of you has any questions about our efforts or what we are working on this year, please reach out. And with that, I hand it over to either Jarek or Wolf. Thank you.
I think it's Wolf. Wolf, very experienced mediator and also very experienced event organizer.
I have a future as an event organizer, I think, but it was very interesting. And I truly thank Jarek for all the work that he did to help us, and Bickel, of course, for hosting this event, because I think this is a fine event to be held after Harvard. And Arvid, again, many thanks to you and your team and Harvard for hosting the very first event, which turned out to be so very insightful into the world of mediation within the context of Investor-State. So as Jarek said, our colloquium last year really brought together a large number of different stakeholders, and that was the intent, to get the view from the various stakeholders in ISDS as to whether mediation actually was a feasible mechanism to utilize within the ISDS world. And so we came away from the colloquium and, as Arvid said, created a working group that then produced a report coming out of the colloquium, and that report was published in June 2020. And what I thought I would do just to begin today is just take you through some of the insights that we gathered in in the colloquium so that we could hopefully continue the discussion today. So let me just, I've got a few slides because I think it'll be easier to highlight the insights by going through slides. So I'll pull those up for you. All right. So a number of key insights that we garnered from this, and an important one to begin with is that mediation is really assisted negotiation. As Arvid said, it is parties coming together to look at an issue or dispute that has arisen between them, and try to find a way to resolve that dispute through means other than adjudication. So assisted negotiation is really a hallmark of mediation, using a neutral to assist in finding a way to a settlement. The other thing that Arvid alluded to, and which is extremely important, we feel, is stakeholder mapping. In many of these disputes, it's not simply the primary parties, the parties that might go to arbitration, that are involved. And there are many other interests involved in a particular dispute, and recognizing those interests and the role that they play and how they might be involved in mediation is also an important factor. We know that transparency in ISDS is an issue that has been particularly discussed in arbitration. But if we're looking at mediation in the context of ISDS, we also have to consider transparency. And as we know, mediation is a mechanism that relies heavily on confidentiality. And so that dynamic between transparency and confidentiality and how each might be applied is another area that has to be looked at in the form of ISDS mediation. We also recognized that political actors are, of course, at the heart of ISDS and ISDS disputes. And one of the key takeaways, I think, here was that political actors may prefer actually to have a dispute resolved through a formal mechanism. That's why arbitration has really been at the heart of ISDS dispute resolution for many, many years, because it is a forum in which a third party, the arbitrator or arbitral tribunal, makes a determination, and it's easy then for the political actors simply to abide by that, because that decision has been made in a different forum. Mediation, of course, results in a settlement where a party has to decide that they wish to settle, and that in itself might be an obstacle with respect to political actors. Another thing that we have to recognize is, of course, there are different forms of states in the world. There are states that live by rule by law, and others rule of law. And the mechanism that is utilized, and in this case mediation, has to be a viable alternative within the framework of any state. And so that's another area that we thought needed to be looked at. There was also the idea that maybe mediation has to be explained to stakeholders, specifically because in a formalized system of dispute resolution that they've been used to, there are, of course, certain norms and rules, and mediation doesn't quite fit into that type of formal dispute resolution mechanism. And so the idea of how mediation is going to be used, the timing of mediation along the timeline of the conflict development is an important issue. And so it's something that requires awareness building. So we will say a number of times, I think, and look at certainly in panel number 1, the need for awareness building to ensure that people understand what mediation is and how mediation fits into the dispute resolution spectrum. For investors, and my own background is from an investment background, having worked for several multinational companies in an in-house capacity, excuse me. It's often the case that when you're facing a dispute with a state that is your customer, you become very reluctant to actually employ formal dispute resolution mechanisms, be that litigation, be that arbitration, because that's really the nuclear option. At that point in time when those are deployed, your investment really has run its course, because it's very difficult then in that situation to continue a relationship. So that for investors, mediation does perhaps provide an alternative which could be very effective and of interest to investors, simply because it's a non-confrontational mechanism that in many cases allows relationships to continue. So from an investor perspective, it can be quite effective. The other major players, of course, in this area are the law firms, the international firms that represent states and investors. And the conventional wisdom, I think, has been, whether that's correct or not, that perhaps the international firms are invested in the current model of ISDS, because that's the model that's been utilized for many years. And so that they're not interested in mediation. But that, I think, certainly if it was true at some point in time, is changing now. And the firms are becoming more interested in the utilization of mediation as a tool in this area, and are becoming very much more involved. So that's another actor that can be very important in the development of mediation in this context. So just some takeaways, and Arvid already alluded to some of these, but the question of transparency, as I said, is one that has to be looked at, and how transparency in ISDS mediation in particular is going to evolve. The use of mediation is just another tool in the toolkit of dispute resolution, of course. And the question here is really how mediation will be employed, and how it will develop within the context of ISDS. And in our keynote speaker, Meg Kenyer, the Secretary General of ICSID, is going to talk a little bit more about that, because ICSID has taken a leading role in the development of mediation in ISDS. Institutions, speaking of ICSID, but others, are really key to the development, we think, of mediation, both to facilitate it, but also to build capacity with respect to the use of mediation. And that requires then also the training of individuals that are skilled in mediation, the ISDS world of mediation, which is quite different from normal commercial mediation. States themselves should work, and we'll hear from Alejandro Carbello, who has been a leader with ECT in developing a framework through which mediation is being utilized in the ECT framework. And we're going to hear more about that. And states within the ECT have been very interested in utilizing mediation. And so the ECT has developed a framework through which they can actually utilize it. So that will, I think, be an important model. And then, as I've already said, the law firms are extremely important, both from the investor and from the state side, to not only encourage the use of mediation, but help to design mediation into the dispute resolution process. There's also a greater awareness of states, and we're going to talk a lot, I think, in some of our panels around FDI, foreign direct investment, and how mediation can actually be utilized to help promote that, because states, and particularly now with COVID and the post-COVID world, are going to be scrambling to actually attract investors, and having better communication between investors and states, but also having mechanisms for early dispute resolution will be an important element of attracting investors. And so that's another area that needs to be looked at. And states, in order to really promote mediation within their dispute resolution mechanisms, will have to make arguments such as FDI to bring their own society along with the use of mediation, and to make it a legitimate tool for states to actually utilize to resolve their disputes. So with that, what I'd like to do is I'd really like to set the stage perhaps for the rest of our program over the next 2 days. And that is, we will be looking at some of the themes, such as the trend for globalization and international investment in the post-COVID-19 world, with the pushback on globalization that we see at the moment, and increasing criticism of ISDS, is that a catalyst for helping to develop mediation in the investor state world. UNCITRAL has played, of course, a huge role here, first with their working group 2, and as Jarek said, the Singapore Convention, which came into force in September of this year, Working Group 3 of UNCITRAL is now reviewing ISDS reform. And an important element of that review is how mediation fits into the ISDS process. So I think we're going to get a lot from UNCITRAL Working Group 3 around mediation and the framework for it and how it can work. So we will continue now to explore, I think, in through our panels over the next 2 days, different aspects of how mediation can continue to evolve in ISDS and how it can be utilized further. And I think this will be a very interesting discussion, and I do actually encourage anyone who has comments, who has questions, to post those, because all of our panels will be interested in hearing from you. And we hope to make this a little bit more interactive. It's difficult, of course, in the virtual world to really do that, but to the extent we can, we'd really like to encourage the use of questions. And so we look forward to that. So with that, actually, I would now like to turn to our keynote speaker, who really needs very little in the way of introduction. Meg Kenyer is the Secretary General of ICSID. And as I said, ICSID has done an enormous amount in the last few years to help reform the ISDS system, including the proposed introduction of mediation rules. And ICSID has also been an important player in helping to bring awareness in respect of the use of mediation and also training, and that's extremely important given the role that ICSID plays. So with that, Meg, if I could perhaps turn to you, and if you don't mind, if you are there, it's hard for me to see, of course, to start.
We'll need to promote Meg to become a panelist. Okay. Liam, if you can see Meg among the attendees.
Sorry, Jarek? Can you say that again for me, Jarek?
Yeah, Meg Kenyer. Mm-hmm.
Thank you. This is good to be promoted. Nice to join you today, even though virtually, and nice to join all the participants. As Wolf has probably explained to you, today's events build in many respects on a conference that was held last year at Harvard University. And this, of course, continues the momentum of investor-state dispute settlement and the Investor-State Dispute Mediation Working Group that was created after that conference. I think that working group is a further reflection of a real increasing interest in mediation in the investor-state dispute settlement world. And we've been seeing this gain momentum in roughly the last 5 to 10 years. In a way, this is a bit ironic when I look at the roots of ICSID. In 1966, when the ICSID convention was established, the drafters included arbitration and conciliation mechanisms, but they were absolutely convinced that the instrument of choice would be the conciliation rules. I suspect their expectation was based on a number of very successful interventions by the World Bank in the 1960s, when it was able to use its good offices and to facilitate negotiated resolutions in a number of large-scale disputes. But if you fast forward to today, while ICSID has been a unique success, ironically, it's been the ICSID arbitration capacity that has been used by parties. Of the more than 700 cases that we have administered to date, only 13 have been conciliations, and none have invoked our fact-finding rules. So the question really is, why is this moment different? And we think this moment is different for a number of reasons. Generally, there is a much greater awareness of mediation and similar tools, and that kind of awareness did not exist in 1966, and in fact, I don't think has existed until really relatively recently. There is also, importantly, a track record of success for ADR type tools in a number of domestic contexts, and I think that clearly lends credibility to the idea of using these tools in the investor-state context. I think, for example, of mediation and conciliation and how they've become probably the main dispute instruments in diverse domestic contexts, things like labor law or family law or indigenous right claims, where they've proved that they're very much up to resolving some very complicated disputes with multiple interests and multiple parties. Closer to home, I think we've also seen a lot of success recently in mediation of commercial disputes and contract disputes. And that again provides a successful track record for cases that are probably in many ways analogous to investor-state dispute cases. The moment is also probably different because we have been seeing an increasing number of investor-state disputes. And in terms of numbers, I think you're all fairly familiar with them. The first ISDS case at ICSID was in 1972, and by now we have globally roughly 1,000 cases. And we know the expectation is there will be on average about 50 to 60 new investor-state cases every year. All of this increased experience and increased awareness of arbitration in investor-state cases certainly has demonstrated a lot of the advantages or capacities of arbitration, and in particular, its ability to reach a binding and enforceable resolution. But at the same time, it's identified some concerns, and perhaps the lesson that's got to be taken away is that in investor-state dispute settlement, one size does not fit all. One of the biggest concerns about arbitration, of course, is cost and duration. And quite frankly, cost is a direct reflection of the amount of time taken. So if mediation can resolve a problem more quickly, that in and of itself is a large success. Another very important consideration is the effect of the dispute resolution process on the relationship of the parties. I know that many see investor-state arbitration basically as a last resort to recover pecuniary losses that a party may initiate after all other resolution tools have failed. And that, of course, can damage the relationship of the investor and the host state, sometimes irreparably. Given that the very purpose of investor-state dispute settlement, be it arbitration, conciliation, or otherwise, is to encourage foreign direct investment, we really need to be open to these alternate ways of resolving disputes. Ways in particular that encourage the investor to stay in your jurisdiction, that allows the state to retain the investments it's attracted, and perhaps even encourages them to expand and diversify in your jurisdiction. And while we always talk about investor-state in particular as attracting investment, the retention and expansion of investment is as critical, and mediation may very much contribute to this goal. We've also seen several recent initiatives that have built on this momentum. I think, for example, of the 2012 IBA rules, which were the first set of mediation rules developed specifically for investor-state dispute settlement. I know in the last several years, the Energy Charter Secretariat and their members have done a lot of work in this field. And if you've not read it, I would highly commend the Energy Charter Secretariat's Guide on Investment Mediation to you. We also have in parallel a working group number 3, and as well working group number 2 at UNCITRAL, who are working on reform issues in investor-state. And working group number 3 in particular has mediation as one of their areas of focus. At the same time, we're seeing a number of the new investment treaties, including the EU treaties, who will include express provisions encouraging mediation. So to give you an example of the typical clause, Article 8.20 of the Canada-EU agreement gives the disputing parties the opportunity to have recourse to mediation at any time, and they note expressly that recourse to mediation is without prejudice to the legal rights or the position of either party. Perhaps the most important development in the last little while, though, I think, is the Singapore Convention. And that, of course, was signed in 2019 and came into force in September of this year. The convention, of course, provides for cross-border enforcement of negotiated resolutions. So it allows a mediated settlement to become enforceable in the signatory states. And we believe that the Singapore Convention is going to give parties real confidence in trying mediation, knowing that if they succeed, they will have an enforceable resolution. I'm proud to say that ICSID has played a leading role in all of these efforts, and I want to commit to saying that we are going to continue to do so. We think this is a very important aspect of investor-state dispute settlement moving forward. My colleague, Frau Konieczka, will introduce you later on today to the proposed ICSID mediation rules, so I will not go into those in detail. But I do want to make a general point, and that is that our recent amendment efforts have basically updated arbitration and conciliation, and to make conciliation a much more flexible ADR or modern ADR type of tool. But we have also provided standalone modernized rules for fact-finding and new standalone mediation rules. And these are made broadly available for use, even if a party is not an ICSID member state. And really the philosophy behind all of these amendments is that parties should have access to a suite or a menu of dispute resolution tools, which can be used selectively as is best for the case. So we do not see having these options as mutually exclusive alternatives, but rather as mutually reinforcing ways to get to a resolution of a problem. We know, for example, they might be used in the cooling off period, which is typically found in most investment treaties, and before actually launching an arbitration. We know they might be used instead of arbitration, but we also think of sort of hybrid situations, which I think are really an interesting and creative opportunity. So think, for example, where parties might mediate one part of a case while arbitrating another part of the case. Or think of a case where the main issue is liability, and once liability is decided in an arbitration, they might then go to a mediation to figure out the remedial portion of the case. A similar kind of hybrid would be where there's a ruling on jurisdiction, and then you could pause the arbitration to mediate. There are a lot of these kinds of possibilities, and that's the kind of flexibility that we wanted to give to parties by having these new tools. I think this is a good opportunity, a good option, but if we want to get maximum benefit, we then need to think about some of the challenges and how we address some of the challenges. I think first and foremost, there is a challenge in terms of capacity building, and that is both within government and within the private sector. As Wolf has mentioned, ICSID's been very involved in this, and we've given numerous introductory courses about how mediation could be used in the investor-state context, and we've circulated a lot of information to various parties. We have also worked with the IFC, another arm of the World Bank, on a dispute prevention model for states, and that includes resort to mediation. And as part of that, we've given training to some of the government officials on mediation skills. We are currently drafting model clauses for mediation with the UNCITRAL Secretariat, and those could go into either a treaty or an agreement. And I think the other day we were on a conference where one of the conference speakers called this the low-hanging fruit. And in fact, I think it probably is. If we start seeing more mediation clauses expressly put into contracts and treaties, that is going to be a huge incentive and a huge marker for parties that this is an option that they ought to think about. We are also preparing a checklist for states to provide guidance on how to prepare and participate in a mediation. So there is a huge amount of capacity building that is ongoing. A second challenge, and it's related, I think, to capacity building, is ensuring what I'd call government readiness. And that has a number of arms to it. Basically, governments need to review their domestic framework to ensure that they're ready to mediate when a dispute arises or when they receive a request from a party asking to enter a mediation process. This may mean consideration of the statutory framework that applies to the government officials, but in particular, I think it will mean looking at the administrative framework or the unofficial framework of what they work in. So this means, for example, trying to set up something like a lead agency that knows a bit about mediation, that can explain it to whatever clients or government departments are specifically involved, and that can ensure there is a coordination and also an acceptance or a willingness of trying the process. They need to also know, in particular, who are the officers that can give instructions and be able to implement a mediated settlement. And in that respect, you'll see there's an interesting clause in the new ICSID rules actually requiring an individual to come from each party saying and explaining that they are able to explain and to carry a mediated settlement into the implementation process. So you know from day one that there is a sincere effort and there is a real ability to implement if you actually are able to resolve the problem. We also need to consider some of the problems around individual liability. We've heard a number of state officers who are concerned that if they resolve through mediation some kind of a dispute, they might later be susceptible even to something as drastic as criminal charges for having compromised a government interest. So we have to make sure that they are not going to feel exposed when they try this process. The other issue is more almost a psychological issue, that mediation is not showing weakness or liability or capitulation or any of those kinds of words, but rather that it is a very effective and appropriate dispute settlement mechanism in the right cases. There was an interesting survey by the National University of Singapore, and they identified what I think a lot of practitioners realize, which is for government, one of the main barriers is that officials or the people they report to may want to kick the can down the road, basically defer a decision so that they don't have to engage with all of the potential political problems about resolving a dispute by mediation. And so making sure that those officials understand what the process is and why it can be an advantage is also very, very important. And I think as part of that, thinking about your communication strategy as government is also important. Being able to say, we've entered this mediation process, and here's why this is a good thing and not something that should be criticized or shied away from. So having a strong understanding of what mediation is and what your framework is within government is going to be a very important challenge to meet. A third challenge that everybody has identified, of course, is having a cadre of expert mediators who can do this work. We know this is a new field, and so there's really a question of where do you turn to find investor-state mediators. And it becomes almost a chicken and egg problem in some respects. Do you take mediators and turn them into investor-state experts, or do you take investor-state experts and turn them into mediators? Either way, you need somebody who understands and is able to work well in both of those milieus. Again, capacity building comes into this. And for the past 3 years, we've run a number of training courses for mediators together with SETR and the Energy Charter Secretariat in Paris, Hong Kong, Washington, and these have been very, very successful. Last week, we did the first virtual mediator training, and we've got to keep these efforts going so that we can develop a pool of people who have the capacity, and then more importantly, a pool of people who have actually done this work, so we're able to call upon them when a case comes up. So that is a long-term effort that started, and we're at the beginning of that arc. Fourth, I think it's really important to have some success stories to try and encourage people to try mediation. And my sense is that that means finding a way to identify cases with the potential to mediate. We all know there are some cases where, for whatever reason, maybe the parties are at such loggerheads, or maybe it deals with really an abstract policy issue with multiple ramifications, or maybe the parties want only damages. There are some cases where you can see it's going to be harder to mediate than not. And this brings up an interesting debate that we've seen at UNCITRAL and in a number of fora, where there's a question about whether treaties in particular should require mandatory mediation. And this is one I have to admit that I am of two minds on, and I think it's easy to understand the benefits of each position. There are those who say mandatory mediation is a good idea because it really doesn't hurt to try. You may find out quickly it's not going to be successful, but you don't know until you've at least tried. So having a mandatory mediation phase may well be an important aspect of these treaties. And again, we've seen a number of civil regimes in domestic law where there is mandatory mediation before you can start litigation. And it has been very effective in terms of reducing caseload. So there may be something to that. On the other hand, there are those who feel that there are some cases that are not liable to be successful in mediation. And really the key is to identify those cases that are going to be successful, or that have a hope of being successful, and putting our resources on and our efforts towards those cases. I think however you identify whether a case is one that would be appropriate for mediation, we have made the choice to leave that to parties. And what the institutions are doing, which I think is very important, is giving them a checklist of things that will help you decide what is the right tool at this point, and would I be better trying to mediate, or is that something I want to hold on to for later in the process? So I think all of this points to the conclusion that there is real opportunity to bring mediation into the mainstream of investor-state dispute resolution now. ICSID is available to administer these now. And in fact, we've advised a number of parties that they can agree to mediate at the center now using the proposed mediation rules by consent. And we've decided for the time being not to have a registration fee, and hopefully we can incentivize a few parties to try mediation in the next year and to create some of those success stories that we think are so important. I think as we hopefully go into a post-pandemic world, we really need to contribute to the efforts of all countries to build back. We see states are trying to manage huge debt loads and high unemployment, and all of that on top of pre-existing challenges like climate change or food insecurity. And these are all real incentives to try to attract FDI, and in particular, sustainable and high quality FDI. And from a dispute settlement perspective, I think mediation should really be a full partner in these efforts. So conferences like today, I think, are helpful, and we look forward to seeing even more development in the next year, and hopefully some real cases and some real success stories being developed. So I wish you a wonderful conference, and I thank Jarek and Wolf for having us attend and participate, and I look forward to the rest of the conference. Thank you.
Thank you, Meg. Meg, I wonder, we still have a few minutes left. I mean, do you mind if I ask you a few questions?
Absolutely, it'd be great.
Coming out of your keynote, which was tremendous, and that was a great way to, I think, kick this off and also give us a good impression of what is currently happening, because there's a lot happening right now, and this year in particular has been full of things that have helped, I think, mediation along. And the COVID situation, I think, and the pandemic will also be a catalyst for that. But I was wondering, just going back, and you were discussing that the founders of ICSID really felt that conciliation would be a primary tool and not arbitration. And conciliation, of course, even in the ICSID framework, is non-adjudicative. Why do you think conciliation never became very popular?
I think there are a number of reasons. And if you look at our conciliation rules, well, I think they were a huge innovation for 1966. They are still fairly formal, fairly rigid. They're not the kind of modern ADR type conciliation that we see now. So I think that may be one of the reasons. I also think the main reason is probably because a lot of parties didn't put into their treaties or their contracts that you could use the conciliation process at ICSID. And if you look at the cases, the 13 cases that we have, many of them are contract cases that expressly send the parties to conciliation and the conciliation rules under ICSID. And that's one of the things that really makes me believe this is the low-hanging fruit, and having some model clauses and actively putting those clauses into contracts and into treaties is going to be a real jumpstart to using mediation in this milieu.
Right. I mean, statistics show that a lot of the cases that are commenced actually don't then proceed to an arbitral hearing. Do these cases settle, or do people just generally let them go because they don't want to pursue them? I mean, do you have some idea of why that occurs?
We have some idea. We know overall that about 30 to 35% of the cases that start at ICSID do not go all the way to a final award. So for those 35% of the cases, they drop off at some point. Some of them drop off for reasons other than settlement. For example, a party runs out of funds and just decides they're not interested, or that kind of thing. But many of them do settle. And we see various parts of the process where there is an opportunity or a time for settling. I think there's a very interesting article by Roberto Echandi that almost puts it into 4 quartiles of where a mediated or a facilitated resolution is most likely to arise. And interestingly, it's not just before you start the request for arbitration or before you file your notice of arbitration. There are actually a track record of cases that resolve in the middle, where we see parties will suspend their case to move off into a facilitated resolution forum. And we've even seen cases towards the end, this whole idea of you have a ruling on liability, let's try and have a negotiated resolution, and maybe one that instead of just pecuniary damages allows you to keep the industry in your country, maybe to give them a concession or to give them a different concession or some kind of a more creative resolution that really meets the goals of both parties, and not just here's your damages and thank you for being here. So I think that's what we are seeing in terms of settlement. And so a large part of that 35% are cases where there is some kind of facilitated negotiation, mediation, that kind of a process. And that gives all of us hope that there is room to do this more formally and more often.
Yeah. I mean, one of the areas that we looked at in the colloquium was, from the investor perspective, investors generally are very reluctant to adjudicate against states simply because they've made their investment there. And it's simply in situations where they are forced to adjudicate that they generally do. But states, as we have seen, and as you've also already alluded to, have many other considerations, not just the commercial consideration that the investor has, but rather they have a lot of political and social concerns that also influence their decision making. And I know one of the areas you've been very keen on, Meg, is also awareness building with states themselves. I mean, how can we actually build that kind of awareness and the utilization of mediation as a mechanism by states?
Yeah, this is the capacity building. And I think capacity building in anything with states sometimes is a bit daunting, because states have a lot of turnover in officials. And as you say, Wolf, they have a lot of interests in parallel and not just the economic interest to resolve the case. So basically, we just keep trying to do these courses, trying to make them as available, as widespread as possible, trying to have written materials that people can use and to bring about this kind of awareness. I have to say, one of the things that was actually a really good opportunity in this sense was when we were negotiating the mediation rules with our states. So we had 155 states actually looking in depth at mediation and how you would mediate in the investor-state context. So all of this sort of builds the awareness with the states, but it has to be just a constant effort.
Wolf, can we have a few minutes and try to pick up a few questions from the Q&A box? Meg, can you see the list of questions?
Yeah.
Shall we, how many minutes do we have, Wolf? Shall we promote someone to ask a question, actually?
We have about 20 minutes left.
Oh, okay. So how about promoting Dmitry Davidenko to ask the first question? We can use video and then he can ask the question. Is that okay?
Tremendous.
Yeah. So Liam, could you please promote Liam? And I would encourage also all attendees to like the questions in the Q&A box, because those which receive the highest number of likes are more likely to be picked up. So Liam, could you please promote Dmitry Davidenko to the panel? Thank you. And introduce yourself if you. Dmitry, you are now promoted, so if you could unmute yourself and ask your question. If you could use video, good. If not, that's fine. I think while we're waiting for Dmitry to resolve his voice problems, maybe we can also, Professor Kisajan could also be added to the panel, because she already has 3 likes. Good question.
Actually, I can just get right to Professor Kasejian's question, that perhaps, excuse me, the conciliation rules were modeled on state-to-state conciliation processes. And I think that's quite correct. That was certainly one of the influences and the obvious sources that was out there for the drafters of the convention. But I think the main reason investors didn't buy into it was that it actually wasn't expressly made available in contracts or in treaties. So you had to really know that it was there and take the initiative to ask the other party if they would consent to conciliation. To me, having those clauses right in the instrument of consent is a really important part of making them usable and of interest to the parties.
Professor, anything to add in response?
Nothing to add at all. Meg said it all. Thank you so much.
Maybe I can see Dmitry, if you're...
Could just read the question then, I guess.
Yeah, why don't I just... So Dmitry's asked about power imbalance being a challenge in mediation. And in investor-state relations, usually the investor has less power than the state. So how does the mediator deal with this power imbalance? I think it's an interesting question, and it's one I'll tell you my sort of first gut reaction. I probably would like to think about it a little bit more. One of the interesting things we see in investor-state is, yes, sometimes the investor has less power, but in some respects, sometimes a big investor or an investor in a key industry actually has a fair amount of power because the state is quite aware that they want to keep that industry in their host state. So actually the power relationship or balances can be quite different depending on the factual circumstances. All of that said, I think, how does the mediator deal with power imbalance? That's a question you always have in these kinds of cases. But among the various ways they can do that, I think, are using some of these traditional tools, things like caucusing, speaking to one side, then speaking to the other. They are able to, if necessary, bring in a third party where there's a third party interest that's really important. They are able to bring in the expertise that might be needed if the parties can't. So I think having some of those flexible tools really can help with that power imbalance. But all of this goes back to having a mediator who knows and has the skills to use those kind of tools. It all goes back to skilled mediators, which is a really key issue. And developing that and getting the experience is really, really important.
Shall we promote Elise, who now has a question about mediation for human rights, environmental and workers' rights. Then they will have a question about Brexit. Well, Pickle is in the UK. So maybe we can promote two people at the same time so that they can use voice to ask their question.
Good. Should we start with Elise?
Yeah.
Hi Meg, hi Wolf,
Hi.
and hi Professor Kiroli. I just, did you read the question? You want me to repeat it?
Yeah, no, I've read the question.
Okay. I'm a human rights lawyer. I'm also a mediator with IMI, and I was invited to join that group in 2017. And I've been trying to promote. I'm sure you're aware of the field of business and human rights and the UNGPs.
Exactly.
And I wrote a paper on the subject. Anyway, I haven't seen much progress in that field. I feel that it's kind of essential to try to move in that direction. COVID helping or COVID oblige, I think these issues are more and more pressing. I mean, they take place in contracts, for example. I mean, when companies decide because of clause of force majeure not to honor their contract, they're putting hundreds, sometimes thousands of people in the streets. They're not necessarily wanting that result, but they have to be aware. So I have tried to promote co-mediation by introducing human rights experts, workers' rights experts, environmental experts on these issues, so that we can look both at the human factors, but also at the remedies to make sure that these conflicts find a human resolution, and to make sure that going forward, we try to prevent protest and help these investments to go more smoothly. You might be aware of the financial regulations in Peru who are forcing some kind of, I mean, it's not mediation, but they're forcing banks to get into social resolution of conflict with companies before granting financement for project. So I wanted to have your thoughts. I've spoken too much. I'd like to have your thoughts on the subject.
No, I mean, I think just generally mediation, co-mediation, however you want to do it, is really useful for those kinds of problems. I was on a panel a couple of weeks ago where we had Phil Fontaine, who is one of the main Indigenous rights representatives in Canada, has a long history of this. And there was litigation for years and years and years. And he spoke, I thought, incredibly compellingly to how when they went to mediation, problems that had been dragging on for decades were resolved within 2-3 years. And it's a really important testimony to how some of these other sort of non-strictly economic problems can be well dealt with by mediation, and especially with the flexibility in terms of remedies. That's really key. In the investor-state context, there's been a lot of discussion about can you pull in human rights, environment, those kinds of issues. And really, a lot of it gets back to the basic structure, which is these are asymmetric documents. To the extent it's based on a treaty, the treaties put obligations only on the states. And so you need to bring in express obligations on investors. For example, if you go into a country, you have to meet their environmental standards for construction or whatever it is. So you would need to start putting those into the treaties expressly, as well as perhaps expanding the kinds of obligations that states take on if you're going to really see that kind of mediation take hold in the strictly investor-state dispute settlement world. And we're seeing a move towards that. It's still tentative. I think, probably the main thing we'd look at is a number of treaties have these corporate social responsibility clauses. They are very much hortatory at this point, but we are seeing slowly a move to that kind of environment. And once you get those obligations, then obviously they would be clearly subject to mediation.
If I may add to your point, first in the Canada-Europe Treaty, you have in the preamble the mention of human rights. So I think this is already a first step in the right direction. And you have a movement in the investment world about ESG, better ESG, as being, of course, the social issues. So I think, I mean, waiting for treaties, we're going to wait for 20 years. I mean, treaties take a long, long time to happen. But I think it's up to the mediators or to the process to make sure that these issues are addressed from the get-go, to tell people we need to have a different set of experts accompanying us in this process to make sure these issues are addressed. And I'm sure that the mediators that are in charge of these processes can request that they be accompanied by these kind of experts. Unfortunately, I do not believe that people who have worked in commercial law their whole life have the kind of lens needed. It's not bad faith on their part. They just don't have that kind of understanding of the issues or sensitivity or ability to listen to parties about these issues. I think it takes several people to make sure these processes are unfolding the right way. So thanks a lot for listening to me. Thanks.
Just now, Dr. Hedeman is asking if we expect to see an ADR clause or facility in the current EU-UK trade deal. I don't know, but obviously it's something that I would not be surprised if at the very least they are thinking about and considering. When you look at the EU treaties we've seen to date, and obviously there's a real awareness in the UK about this. And I think bringing forward some of our model clauses could actually contribute to that kind of thing. I see Barry Leon has asked about what's being done to make sure individuals are not exposed for agreeing to a mediated settlement or any settlement. And it's a really good question. In some places, it needs changes in domestic legal framework and in the kind of framework that applies to protect an official working in their official capacity. So that is something down the road, and that's why we've been saying this is one of the elements of awareness, that parties really need to look at that and make sure they've covered that somehow. And we are starting to see this, but it's at the very, very early days. One of the things that I think will be useful, and again, one of the impetuses for us to put into our exit mediation rules, that you bring an official, presumably a senior level official, who says, we're authorized to enter this mediation and we have the ability to implement a mediated resolution, I think will be to help shield any one individual from that kind of liability, and to really make it clear that this is a decision and a conduct of the government as a whole, that it is authorized, that is in the course of official government business, so that it shouldn't result in liability to any one poor individual who negotiated a resolution and then found this wasn't looked on as favorably as it had been at the time. So that's one of the pieces that we are doing.
Shall I ask the next two people, Herman and Marion, to ask their questions using voice, Liam, or if it's too complicated, we can just use text?
Yeah. Hi.
Hey,
yes, hello, Meg. Sorry, I was listening very carefully. Now, allow me to. I did attend one of the training courses, so I was very happy to do that. And in fact, they've told us also that in investment mediation, you may well have non-disputing third parties involved. And you did not mention that, but I thought that's probably something useful to mention, namely, you have public society, civil society also, who have an interest in a case. It's not only between the investor and the state. And I would think that, in fact, that's a question also. I would think that particularly mediation may be useful there, because it's not always clear, particularly if you're in an arbitration. The non-disputing third party might get involved also in an arbitration, but then the question is, well, what position shall he take, on whose side, etc. Whilst the mediation atmosphere, I might say, possibly could be helpful there. And you did not mention that in your presentation, but how would you see that?
Oh,
Is
yeah.
that not something also that you could mention, maybe, that it could be in the interest of public society also? I mean, mediation, and then of course you would have to explain to the investors how they would have to cope with that, and the states as well. So could you maybe have some views? And then secondly, I was interested, because in the statistics you don't mention that the 13 conciliations that you had in the past were somehow representatives of civil society involved in those 13 cases. Do you know about that? Or in those days, maybe you did not have that? So these are my questions. Thank you.
Actually, one or two of them are ongoing now. I don't recall, to be honest, third parties or civil society being involved in those. I stand to be corrected, but I can't tell you off the top of my head that one where there certainly was. In terms of involving third parties, absolutely. I mean, that is one of the things, and I guess obviously it depends on the dispute. If it's a strict commercial dispute, probably two parties is enough. But if it's something that starts to implicate in particular social measures or those kind of issues, you may well see that if you want to have a mediated resolution, it might need you to bring in a third party, and that you don't want to mediate something and then have the third party bring up a problem and not have a full whole solution. So that absolutely is one of the benefits for certain. Yeah.
Yeah. Okay. Well, thank you. Yeah.
Yeah, and if I may, I mean, that was one of the points that came out of the colloquium that we held last year, and that's the concept of stakeholder mapping, and looking across at who are the parties other than the primary players who are involved, and to what extent should they be involved in the mediation to get a proper resolution that's beneficial to everyone. And mediation, of course, allows that in the flexibility that it proposes.
Of course, it raises the issue of transparency. Obviously, that's some of the things people will have to take care of, because then again, I mean, if these non-governmental entities get involved, some other people would say then, oh, why do they get involved, etc. So it's an issue, obviously, how to take care of that, the transparency.
And, you know, the transparency is an interesting one where I think probably I may be of two minds as well. There are some who want this process to be fully transparent, along the lines of almost Mauritius level transparency. Many others react saying, well, some transparency is obviously important, letting people know a mediation is ongoing, that it's hard to have an effective mediation that's fully open to the public. So that is also one of the discussions that's come up certainly in the UNCITRAL and in the ICSID mediation rules discussions.
Yeah, thank you. Right. Okay.
There's a good question here about why ICSID chose to maintain separate corpus of rules, excuse me, in terms of mediation and conciliation. I think there are probably a number, first of all, of practical reasons. We had our conciliation rules. We know there are a number of agreements and treaties existing that refer to the ICSID conciliation rules. So obviously we didn't want to sort of drastically change that mechanism and take that out from the places where it already exists. So I think in a way it was a bit of a practical decision, but there's also a key difference here in that our conciliation rules lead to a recommendation. And we looked at the mediation rules where the parties can ask the mediator not to give a recommendation at the end of the day. And we thought that was a key distinction that made it important to keep them as separate options. So that was the thinking that went into keeping conciliation rules and mediation rules. The other part that was really important to us was being able to do standalone mediation rules meant that we could make them more broadly available. And Frauke will discuss this with you, but a lot of the jurisdictional hurdles under the ICSID rules, the Article 25, you know, directly or indirectly related to investment, we have really reduced those so that mediation is something that's available to parties essentially if they both consent to it. So having a much wider open door to using mediation was also an opportunity for us there.
I think there was an interesting question, maybe the last one, about pre-mediation steps. Are there any other dispute avoidance techniques which you are either actively using or thinking of using?
We're working on these ones basically. There's one I have to admit that I am very interested in, and that's sort of early neutral resolution, trying to almost get a cadre of expert people who would be willing almost to give a pre-opinion. I think that would be a really valuable service. You would have to design it so that those people could do this in a relatively short amount of time. So how do you educate them on the case relatively quickly? It would be completely non-binding, but they would have to be people who had some standing so that it had an impact, so that parties could go back to their clients and say, look, we've kind of had a bit of a dry run here. We don't have a strong case. Why don't we try to do something else, or let's not arbitrate, or whatever. So the one that I guess maybe it's sort of a couple of years down the road, but that I've done some thinking about and we've done some discussing within ICSID would be early neutral evaluation. But at this point, we're really focused on the mediation and getting these mediation rules up and running and having a real strong foundation.
Wolf, it's in your hands now. I think that our time is up, but it's up to you whether you finish or you want to pick up a few.
Well, I think we should allow people to get a coffee, have a bit of a break. And particularly, Meg, thank you so much. That was extremely interesting. And I think that was a great kickoff to this forum. Thank you so much for attending.
Terrific. We'll see you all later on.
Thank you, Meg.
Thank you, Meg.
Bye-bye.
So at this point, we do have a 10-minute break. If you could all be back on the half hour, but do go get a coffee, and we'll then start with our first panel.